Hey there, legal warriors. In this video, I'm going to cover something from the point of view of an attorney. What are mistakes that attorneys often make when dealing with bad facts in a criminal case? And I think this applies all throughout the United States, but of course I'm here to talk about Washington State. Assumptions can often lead to attorneys making mistakes and making the case way worse for their client. If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 25 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. More people get the help they need. Now, as always, I'm just going to jump right into it. What do I mean by a bad fact? Well, think about non-felony cases in particular. And most of us, if we're watching this, if we're dealing with a crime, way big majority of people won't be accused of a felony, might be accused of a DUI or an assault or theft or something like that. And as you might guess, people in the system, prosecutors and defense attorneys, judges, they sort of see the same general fact pattern over and over again, right? In an assault case, on a non-felony assault, you don't normally see a lot of injuries. You might see some pushing and shoving. Maybe there's a bruise. Oftentimes there's not. On a DUI case, you see a standard reason for the stop, right? Maybe it's speeding. You see field sobriety test. You see a breath test above a .08. On a theft case, right? Someone goes into Nordstrom and doesn't pay for something when they leave, or they go into Goodwill and they do a price tag switch. Yes, it's a crime to switch prices. I don't know why Goodwill, that's where we say that all the time, but you must have a pretty bad system for pricing, probably because of the nature of the merchandise and its fluidity. But so what happens, so generally, this people in the system, they sort of sleepwalk through. Yeah, it's the same report, no reason to get excited. But occasionally, we run into a situation with a really egregious or shocking claim against the defendant. And in a DUI case, maybe someone's using racial slurs and calling the officer certain no-nos in the situation. In a theft case, maybe there's like some tussle and push and shove with security, or there's history of other unreported thefts that they find through these advanced camera systems. Or if it's an assault case, maybe there's a particularly egregious or nasty claim of a prior assault. Maybe there's claim of prior SA, right? Or prior, broken bones and stuff that didn't get reported and therefore weren't prosecuted, but it's somewhere buried in the report. So what's the mistake that many attorneys make? And, I'll say that, I was a prosecutor for 7 years, and so I, at the time, had a very high caseload, so I could understand what prosecutors go through. Some prosecutors have hundreds of cases, right? If you have a private attorney, they might have 40 or 50 cases, hopefully. If you have a public defender, they might have hundreds of cases. And I remember once I had a very good attorney who worked here, and she was a very thorough attorney. And she would run into a situation that had a bad fact. And this person, who was also a former person from the other side, was very thorough in how she did work. And so she would make an assumption that the prosecutor actually knew about the bad fact. And so that's the number one mistake attorneys make. They assume the prosecutor knows what's in their own file. And let me tell you, most of the time the prosecutor doesn't know what's in their own file unless the case gets set for trial. Right? If the case gets set for trial, then they do that fine-toothing, they start looking at it differently, but otherwise it's sort of triage, right? Who knows if they've even read it? If you've got 200, 250 cases and a bunch of trials, you look at a report, it's another assault, it's another theft, you don't get into the details. So the mistake the attorney can make is they lead with the bad fact. And now the prosecutor's like, what? That's in here? Oh, I'm going to treat this case way worse. And so a really good defense attorney should just have a general discussion and see if that prosecutor brings up the bad fact. Be prepared to deal with it, but when you lead with the bad fact, you are making an assumption that often isn't true, that prosecutor knows what's in his or her report, and they're familiar with what's in his or her report. Remember, a really good defense attorney, hopefully at the non-felony level, is trying to give the prosecutor a way out from their caseload that helps their own client, right, the defense attorney's client, get the result that they need. And that's based upon the culture of what normal results are, right? Hey, Does the prosecutor normally offer certain types of classes to get the case dismissed, right? In those cases, if you assume the prosecutor has already read the file, you oftentimes hurt your client, right, when you lead with the bad fact. And, if other attorneys are out there watching it, just think about that, right? Think about whether or not you want to lead with the bad fact. Now, if you know, as a matter of fact, the prosecutor knows about it it came up at arraignment or something like that, well, then sometimes leading with it is a good idea to sort of lessen it, right? If you ever watch a jury trial, if one side has a particularly bad fact they need to deal with, sometimes they'll lead with that during the jury trial to lessen the impact, right, that it has on a jury. But here we're talking about negotiating a case. We want to keep our cards close to the vest if it's an unusually bad situation for our client, because sometimes the prosecutor doesn't know that. And if they don't know it, it's up to them. We don't have to tell them. So another mistake that attorneys can make when dealing with bad facts is themselves totally not doing anything about it, right? In other words, just assuming that it's true. Right? Sometimes we can go back and try to show that bad fact didn't really happen, right? If there's a claim that, the security people say that there was a tussle or a wrestle, and why that's a bad fact in a theft case is because they can turn that into robbery, which is one of the most major felonies, right? If you're physically tussling with someone while trying to steal something, that's a robbery in Washington state. And sometimes we can go get a video and show that it's not true, or that they were simply fell or stuff like that. We've had cases where there were claims that our client did something wrong, and when we got the video, because usually these stores have really good video, it can show otherwise. Additionally, in a DUI case, right? Let's say there's a claim that the person was really combative in the breath test room, and many attorneys don't realize that the large majority of breath tests in Washington State have video in the room. But it's not part of discovery. It's nothing that the prosecutor never sees. It's not something the Department of Licensing sees. I don't even know how my firm figured out it exists, but I got really good staff members, and they showed up one day when we did a public disclosure request. So sometimes we can get things to disprove the bad fact should it come up. And I think it's a mistake when us attorneys just assume it's a verity or it's true that something happened. In a claim of SA or something like that from the past, we might run the person's record and see how many other times have they claimed something like this in a protection order. Sometimes there's civil records that are available to show that the claim is habitual. We've actually been successful in a case like that when we've gotten other protection order type claims where the alleged victim was making similar claims against person after person after person. It was their go-to, and therefore we're able to try to cast doubt upon the uncharged claimed bad fact against our client in the past. And so that's probably the second mistake attorneys can make in dealing with a bad fact. And I think the third mistake that the attorneys can make in dealing with a bad fact is, again, not having the client do affirmatives. And then we want the client to do affirmatives, but depending on the type of allegation, we need to be careful of what affirmatives we do. If it's an SA type claim and we need to do a psychosexual evaluation, that sometimes can lead to other things coming out. Sometimes there's a polygraph, and polygraphs aren't reliable, and we just have to know how prosecutors think about the affirmatives. So basically, we need to either deal with it by doing something on the affirmative, deal with it by trying to show it didn't happen, or hopefully not deal with it by not bringing it up, and it never becomes part of the case because the prosecutor wasn't fully aware of the claims, or maybe they were and they just don't care based upon their caseload if it's not directly related to what's going on now with the particular charge. So isn't that interesting that sometimes that most thorough attorney who's never been a prosecutor, who's never lived the prosecutor life, the nightmare it is being a prosecutor, especially in a high volume place, they assume how a prosecutor does their caseload, and assuming that they're thoroughly prepared sometimes lets the bell get rung in a bad way for their client when it never needs to ring at all. So practice pointer out there, agreed. You can feel free to disagree, but that's what I've seen time and time again from doing this type of work for more than 30 years. So hope you found this video useful. If so, please like and please subscribe. More people get to see it, and of course more people get the help they need. More importantly, if you got a criminal matter in Washington State, feel free to reach out to our firm. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.